Once again, a very, very good afternoon to all of you and a warm welcome to the 2022 SICC Asia Conference. We have with us a distinguished panel of speakers who will be discussing the emergence of international commercial courts as a mechanism for resolving cross-border commercial disputes. Let me start this session by introducing our guests and inviting them on the stage. Mr. Nishith Desai, I request you to please come on stage. He's the founder of the research and strategy-driven international law firm Nishith Desai Associates. His interests span a wide spectrum of law, society, and ethics. He's a renowned international lawyer, author, lecturer, researcher, and thought leader. He's regarded as the father of international tax in India and is a true pioneer in the field of international tax law. Welcome, sir.
Thank you so much.
Thank you. Our next guest is Mr. Lawrence Wong. Lawrence Wong is the Senior Director of Business Development at the Singapore International Commercial Court. He has expertise in insurance life, marketing, and business partner development and management. He has served as the CEO of Great Eastern Life Vietnam and has held key positions with multinationals in Singapore and Southeast Asia. Welcome, Mr. Wong. Next, I would like to welcome Mr. Kelvin Poon. Mr. Poon is the Deputy Managing Partner and the Head of International Arbitration Practice at Raja & Tan, Singapore. He regularly acts in major construction, corporate, and commercial disputes for private and public listed companies and China-related investment dispute resolution. He is a fellow of the Chartered Institute of Arbiters. He is also a member of the core committee and the selection committee of the ICC Singapore Arbitration Group. Welcome, Mr. Poon. It is now my honor to invite Honorable Justice A.K. Sikri to the stage, please. Honorable Justice Sikri is an eminent jurist and has served as a judge of the Supreme Court of India from 2013 to 2019. Presently, he is an international judge at the Singapore International Commercial Court. He enrolled as an advocate in 1977 and has specialized in constitutional cases, labor service matters, and arbitration matters. He has also acted as a former judge of the Delhi High Court, as a former Chief Justice of the Delhi High Court, and Punjab and Haryana High Court. Warm welcome to you, sir. I now extend a very warm welcome to Honorable Justice M.R. Shah, who is a sitting judge of the Supreme Court of India. Honorable Justice Shah was elevated as the judge of the Supreme Court of India in November 2018. He enrolled as an advocate in 1982. And while in practice, he specialized in land, constitutional, education, excise, and custom matters. He worked as the Central Government Standing Counsel and also as a special public prosecutor for CBI in the Gujarat High Court. He was a former judge of the Gujarat High Court and a former Chief Justice of the Patna High Court. A very warm welcome to you, sir. Our next guest is Honorable Justice Nageshwar Rao, who's joining us virtually. Welcome, sir. Honorable Justice Rao is a former judge of the Supreme Court of India. He's the 7th person to be elevated directly from the bar to the Supreme Court. He was sworn in as the judge of the Supreme Court in 2016 and retired in June 2022. Prior to being elevated, he served as an additional Solicitor General of India 3 times. He enrolled as an advocate in 1982 and was designated as a senior advocate in 2000. A warm welcome to you, sir. Our next guest, Ms. May Tai, is also joining us virtually. She is the managing partner of the Asia offices of Herbert Smith Freehills. She specializes in cross-border China-related and regional Asian disputes, including international arbitration, litigation, and regulatory investigation. She is qualified as a solicitor in England and Wales and Hong Kong. Ms. May is CEDR accredited mediator and an arbitrator in the Hong Kong International Arbitration Center. A warm welcome to you, ma'am. I would now like to invite Mr. Vyapak Desai to the stage. He heads the International Dispute Resolution and Investigation Practice at Nishith Desai Associates. He has vast experience in investment treaty arbitration, commercial disputes related to shareholder agreements, international trade and contractual disputes across industries. Mr. Vyapak is also a registered foreign lawyer with SICC. Finally, a very warm welcome to Mr. Ashish Kabra, who heads the Singapore office of NDA. Ashish has substantial experience in advising and representing institutional investors, private equity, and venture capitalist funds on both transaction and disputes. He is a registered foreign lawyer with Legal Services Regulatory Authority Singapore and SICC. May I now request the audience to please give a warm welcome to all our panelists. I request Mr. Nishith Desai to open the session with a few words, please.
Thank you, Shraddha. Honorable Justice Emma Shah, wonderful to have you here with us. Honorable Justice A.K. Segre, so nice to see you. Honorable Justice L. Nagen Rao, thank you so much for joining virtually. I know you couldn't make it today here physically, but I'm delighted that you are here with us. Mehtai, thank you. Thank you for joining. And Kelvin, wonderful. We worked earlier together. And Lawrence, we too. I was for 10 years a member of Singapore International Arbitration Center board. And great experience of going through the whole journey right from start to how. And now this new initiative SICC has come up. I think it is going to be very, very interesting. I just want to say thank you. Just want to say how not so excited, but I'm thrilled to have you all here. And all of my friends in this audience, little place. Hope you all enjoyed the tour of this place called Imaginarium. Did you? Yes. Okay, thank you. Keep on coming up if you are really happy. In Gujarati, we say, if you like a food, you will ask it for second time. If you don't ask, that means you did not like the food. So you have to come again here. Anyway, and so I'll just tell one or two things here. We discussed, I think all of you have been briefed on what this place is about. But my excitement in the whole game is to shape the future of law. Hey, we shape the world that we want, okay? And our approach to practice generally has been, look to the future, be prepared. So when time comes, they'll be ready to meet the challenges. So we spend almost 45% time on research, academics, thought leadership on the premise that every new technology, every new business model, every new social, political, or economic development brings along with it a new strategic, legal, tax, or ethical issue. So we look to next 3, 5, 10, 15, 20 years from now and try to see what new technologies will become, how socio-economic fabric is going to undergo change, how political systems are coming under pressures, how all this kind of thing, and try to visualize the future legal, tax, ethical issues and write a lot of papers. And those, then when time comes, then we are ready to shape the world. I think together we do it. We do not do it alone. A lot of you have contributed, and I'm grateful to you for that. So when you leave, we'll give you our research papers. About 60 of them we wrote in last 2 years. Don't forget to take them, okay? And read them, so next time when you come, I can ask you questions. So anyway, but this was, as I said, I'm really thrilled to have all of you here and all of you there, everywhere. What more could be an excitement? Let us keep on coming up with ideas. Find ideas, we'll work together. As you all know, the whole idea is to do something together. We never do it alone. And this is what I would stop here. I have a strict time limitation of 3 or 4 minutes. I may be exceeded Indian Standard Time. I thought it was, but not. So with those words, welcome once again, and thank you so much.
Thank you so much, Mr. Desai. I also extend a warm welcome to all our viewers who are watching us online. We have a great number of audience virtually with us. May I now please invite Mr. Lawrence Wong to introduce SICC, please.
Thank you very much. Hi, is the mic on? Yes, okay, good. Mr. Nishith, thank you so much for giving us the opportunity this afternoon, and not just the opportunity to share about the SICC, but also to see Imaginarium, and such a wonderful idea on that. Honorable Justice Shah, Honorable Justice Sikri, also International Judge of the SICC, Honorable Justice Rao, ladies and gentlemen, and to those online, a very warm welcome. Thank you so much for giving us this opportunity on a Saturday afternoon to actually share with you what the SICC is all about. Sorry, I'm using SICC, but obviously the full name is Singapore International Commercial Court. And it's so appropriate that we're actually having it in this venue, because truly it was a vision, imagination of Chief Justice Sundaresh of Singapore almost 10 years ago to think about what could be the future of international dispute resolution for Singapore. As you can see, I have titled my presentation Appropriate Approach to International Dispute, Commercial Dispute Resolution. Appropriate only because for many years within the legal community, we use the term ADR to refer to alternative dispute resolution. But truly, is it alternative? Because alternative implies either or an appropriate method. And why do we talk about this? Yeah, okay, good. Because how Chief Justice Sundaresh envisaged okay, I'm sorry, this technology is getting the better part of me. Can we go back? Thank you. How he envisaged the SICC was basically he took a look at the growth of trade, business, finance, investment in Asia. And as all this grows, two things will always happen. Number one, there will be more disputes, nature of the beast. But number two, and more importantly, those disputes get more and more complex. It's no longer A sells to B, and B pays A a sum of money. A may be representing a group of investors behind them, and B may be the start of a string of contracts going down the line. And when that happens, parties demand effective dispute resolution services. So the thinking was, could Singapore be a trusted neutral venue for such dispute resolution, whether it's be by arbitration, mediation, or litigation? We are not looking at domestic litigation in that sense, but litigation for international parties. The history of it is, of course, if you think about it, International Commercial Court, or ICC as we want to think about it, is nothing new in that sense, because you have the Commercial Court in London all the way back in 1895, which actually started more as a commercial list. Then there was a huge gap. After that, you actually had the Dubai International Financial Center courts, and SICC in a sense was third. But as we created the SICC, we created it with a very different view, with a very different imagination of what an international commercial court should be like. So, what is the SICC? It's a court for cross-border commercial disputes, including those governed by foreign law. What we are saying is that we will not only just listen to contracts governed by Singapore law, or as most of us are quite familiar with, English law, but it could be Chinese law, it could be Vietnamese law, it could be German law. We will consider it. There's no limits as to whether it has to be civil, common law jurisdictions or civil law jurisdictions. It's a court that we set up for foreign parties, particularly those in Asia, or at least one party in Asia, and it's for those who prefer to have the disputes resolved in the court of law. Because we are an alternative to international arbitration, when we set it up, what we intended to set up was to address some of the shortcomings that international arbitration has evolved into today. But when in its infancy, there were lots of benefits from international arbitration. What am I talking about? If I were to bring you back to post-World War II Europe, where there was a lot of reconstruction taking place, disputes happening then were brought to a court of law, and parties found that there were two major issues. Number one, heavy caseload, which meant that it would take a long time. And number two, just as importantly, being of a technical nature, did the educators, the judges, actually understand the matter? So parties could resort to a subject matter expert, whether it's an engineer or an architect. In those days, remember there was something called Geneva Convention, not very popular, not very effective. So if they tried to arbitrate and have an award brought to a court in Europe, the judge may actually question the jurisdiction of that and actually not recognize and enforce it. Until 1959, when the New York Convention came about and it started growing its popularity, parties found that they had the advantage of number one, speed, number two, subject matter experts to adjudicate, and because of those two aspects, it was fast, it was efficient, and therefore less costly. So that was what made arbitration a popular vehicle then. So when we looked at it and we said, okay, how do we create this court? We created it on two substantive principles. One, international commercial law. Not civil law, not common law, but the lex mercatoria. This would merge the fact together and at least create a jurisprudence that would keep being enriched, that would keep developing with developments. Simple thing. 5 years ago, not even 10 years ago, there were no issues on cryptocurrencies. We are seeing more and more of that happening. And even insolvencies involving cryptocurrency and exchanges. So things like this, if you kept it strictly within arbitration, your awards are confidential, the jurisprudence on decisions made on such disputes will never come to light and then will never help parties grow and at least become more efficient when you have similar disputes happening in the future. Secondly, and just importantly, we basically asked practitioners what did they like in international dispute resolution today. And of course, a lot of it was towards their experience in international arbitration, and it has evolved. So again, it is not purely a common law type approach that we're looking at, and that's where we tried to build this into the court. So what are the key features of the SICC? Think about it. Because we are a court of law, there's open proceedings, there's transparency involved, and that helps enrich things along the way. In terms of procedures, you have the right of appeal, which you will never have in arbitration. The award is final, regardless of whether there's an error in fact or an error in law. There's nothing you can do about it. But within the SICC, if you think that the court of first instance, which is the SICC, had erred in any way, there's one level of appeal. And you avoid party-appointed tribunals. So party-appointed tribunals, if you think about it, could be a double-edged sword. On the plus side, as you appoint a particular arbitrator, you are comforted that the arbitrator should be familiar with the dispute at hand, whether it's technical nature or the fact that there are multiple parties involved and how to deal with that situation. But on the other hand, we've also heard horror stories in the past that sometimes there appears to be a partiality between the decision of an arbitrator with the party that appointed them. So that's something that at least where the SICC is concerned, there's no fear of that because every judge appointed to a quorum in every matter is actually appointed by the Chief Justice directly. Although I would say that at the same time the Chief Justice has said in public that he would consider recommendations by parties mutually to consider appointing a particular judge to a case because that judge may have good knowledge of that particular dispute, whether it's maybe a dispute or shipping dispute in that sense. In terms of jurisdiction over related disputes, the ability of a court to join third parties to a dispute is something that the SICC does efficiently through an order of court. Whereas in arbitration, you are confined by the fact that you need back-to-back arbitration clauses amongst all the various parties, number one. Number two, no party should object to a joinder. Whereas in the SICC, if it makes sense and you prove to the bench why a party should be joined, even though there may be an objection from one of the other parties, the court will still order the joinder. The next thing is in terms of enforceability. We have published judgments with very clear grounds of decision. So this is the one that adds again to a jurisprudence. I would not use precedents in a sense, but it adds to jurisprudence, so there are reference points for future disputes, whether it's within the SICC or within other courts for future adjudication, or even it would probably be referred to in some arbitral tribunals for the decisions that's being made by the SICC or any court of law for that matter. We believe we have a good set of specialist judges who are very well experienced and great depth where commercial disputes are concerned. Again, whether it's IP, construction, shipping, and what have you. So it's not just Singapore judges, but international judges. And my address to all the legal practitioners within this auditorium today and online, in terms of representation, you need not be a member of Singapore Bar in order to represent parties within the SICC. Okay, so long as you meet certain criteria. A very quick chart to show the difference between the SICC and arbitration. On the first line, you would see that in arbitration, a common pool of arbitrators and counsel, the revolving door concept. So today, if I were counsel, I'd like to appoint Ashish as arbitrator, hoping that 6 months down the road, when Ashish is appointed counsel for another matter, he would appoint me back as arbitrator. That revolving door. I think we are all familiar with that concept. But within the SICC, all the judges, international judges who sit in the court, like Justice Sikri over here, outside of his court duties in the SICC, would only be an arbitrator. None of the judges will ever appear as counsel in any of the arbitration matters. The second line is, I'm so sorry, I keep pressing the wrong button. That all the judges are assigned, so the quorum is assigned by court as opposed to party appointment. The third line that you see down here, the case management is court-based. We have the SICC registry to handle the disputes, to ensure that the matters progress in an efficient and effective manner and not subject to the schedule of a principal arbitrator or whoever else is behind it, especially where you talk about ad hoc arbitrations. The fourth row, the availability of one level appeal. I've already mentioned that, which is something you never get in arbitration. Next is ability jointed and related parties. I've dealt with that already. We make all our judges and foreign counsel sign a very strict ethical code to ensure that there's no conflicts of interest that may arise, whether it's with current matters or previous matters impacting on current matters. And the last one is a systematic publication of judgments with very clear grounds of decision, which would again help in terms of future similar disputes and ensure that parties are aware of it, and because they're aware of it, there's a higher chance of settlement without having to go through the whole process of dispute resolution. Just a quick picture of our local bench, and for those of you who are familiar with SIAC in that sense, on the bottom row, our more recent appointments, Justice Andre Maniam, Justice Philip Jeyaretnam. Justice Philip Jeyaretnam was, until his appointment, the chairman of Maxwell Chambers for many years, right? So they are already very experienced dispute resolution practitioners. On the bottom left, Deda Singh, very much involved in intellectual property matters. Two spots on the right to him as Mohan for shipping and what have you. Even our president, the current president of the SICC, Justice Quentin Loh, 30 years practice experience in insurance and construction matters. So there's a whole depth of experience. Not forgetting Chief Justice Sundaresh Menon himself was a former head of arbitration for Jones Day, international head of arbitration for Jones Day. But the other unique part about the SICC is our 18 international judges. Amongst them, 4 former Chief Justices. Top row, David Neuberger, was a former president of the Supreme Court of the United Kingdom. Bottom on the left, Beverly McLaughlin was a former Chief Justice of Canada. Then from Australia, you have Robert French, who was a former Chief Justice of Australia, and newly appointed to the SICC bench, Thomas Bathurst, who was the former Chief Justice of New South Wales. Besides them, we have 2 civil law judges, Dominic Harsher, who's currently still on the Cour de Cassation in France, and Yuko Miyazaki, who used to be the Supreme Court of Japan. So both civil law and common law traditions they come from. And of course, in terms of other significant matters, if you talk about infrastructure and construction, you would have Douglas Jones from Australia, as well as Ben Ramsey from UK, who was the former head of Technology and Construction Court. Our jurisdiction is that we are a division of Singapore High Court. So any judgments of the SICC is a judgment of a superior court of law, and it can, for the purposes of recognition and enforcement in foreign courts. So there's no worries about that. And you have the right to appeal to the Singapore Court of Appeal unless parties contract otherwise. This is the first indication of the flexibility that we provide parties within the SICC. If parties feel that, just like arbitration, they like the finality of the award, so they can actually contract out the right to appeal once the judgment is handed down by the SICC. All parties may also choose, if there are 5 issues to be determined, issues 1, 2, and 3 non-appealable, but 4 and 5 may be appealed. That's the sort of flexibility that parties have. We pay attention to, in a sense, the concept of party autonomy in this case. The claims of the international and commercial nature, without doubt, but just as importantly, there must be a written jurisdiction agreement to ensure that there's a nexus between the SICC and the parties involved. And of course, with that written jurisdiction, there cannot be a claim of foreign non-convenience down the road by any of the parties. The other two matters that how the SIC would hear, one is that cases may have commenced at the Singapore High Court and subsequently be transferred over to the SICC. And the last one that's become very important, and I'll have a slide on that later, is applications under International Arbitration Act. So you have arbitration seated in Singapore under SICC rules. Any setting aside application, for example, can come to the SICC for decision. In terms of foreign representation, now parties will be represented by foreign lawyers registered at the court. In matters, on the first bullet point, is in offshore matters, that is, where there's no substantial Singapore connection. So you can have an Indian party with a Chinese party, for example, and without any other aspects of Singapore, but come to the SICC, and with that, one of our registered Indian registered foreign lawyers, whether it's Vyapak or Ashish in this case, may represent the parties in the SICC. The other point just as important is that questions of foreign law need not be determined as fact in the SICC, but a registered foreign lawyer deemed to be competent in that foreign law may submit the right to the court. We've done that to ensure that there's saving times and costs. And if you're wondering, threshold for registration is not very high, minimum 5 years advocacy experience, no disciplinary action by your local bar, past or pending, and a fluency in English. And no, we do not conduct English tests to ensure your registration. Please do not laugh, because people have actually asked me that before. And once in a while, I would jokingly tell them, well, if you're speaking to me right now over the phone, then I guess you passed. Right? At the end of last month, we've had 86 registered foreign lawyers, amongst them 17 King's Counsel, and the rest. As you can see, the highest number is from the United Kingdom, 32 of them. Then followed up by Hong Kong with 12 and India with 11. Okay? I hope that after this session I have with you, the number of Indian RFLs actually would exceed Hong Kong. Right? But not just from common law jurisdictions. You can see there's Belgian, there's French, Swiss, Vietnamese, South Korean, Japanese, and Chinese lawyers who are actually registered at the court already. After 6 years and the experience that we had when we launched the SICC back in 2015, and given the fact that the procedures, the rules within the SICC is so different from Singapore High Court, we decided it was time to spin off the rules of court for the SICC into its own standalone rules. So April of this year, we implemented SICC Rules 2021. At the same time, we took opportunities to sort of enhance it based on the experience that we have. So besides the general principle of procedural flexibility and the fact that a lot of all the matters within the SICC are judge-led for the case management conferences, the fourth point about procedures compatible responsive to the needs and reality of international commerce. So it is not so much restrictive. The judges within the case management conferences actually work with counsel to ensure an effective and fair outcome for all. But the other interesting point was we introduced a third adjudication track. In the past, it was either statements, pleadings, or statements. What we've now permitted within the court at the first case management conference, that if parties mutually agree, a memorials track. So pure submissions and a judgment, a decision to be handed down immediately after that. That's for matters that are probably less complex and not much evidence that needs to be established or adduced in that sense. But the point is that what we are providing for is more efficient resolutions too. We are ADR friendly because what we want is to ensure that parties can try to achieve settlement up front and early. So what has been incorporated in the SICC rules today is if parties are encouraged to attempt mediation, if one at the subsequent case management conference, counsel reports that the other party was not serious in it, it shall be noted by the court. If that party is unsuccessful at the end of the day, the cost awards against that party could actually be higher than necessary for that. Or if both parties refuse to attempt mediation and the court feels that mediation could be an outcome, the court could actually order mediation. But it's not a default position, unlike I believe in India for commercial matters. With tightened evidence, expert witnesses can only be appointed with the permission of the court, and the court would actually try to encourage appointment of a single expert witness, and even witness statements have to be in a true sense a witness statement and not affidavits that could allude to matters that the witness signing off on may not have knowledge on that. So it's things like this that we've done to tighten proceedings. I've mentioned about SICC as a supervisory court for arbitration matters within Singapore. So we've done this. Parties can benefit from the SICC's expertise with the presence of international judges who are also established arbitrators in own right. So that's the first advantage. Second advantage is in terms of costs. Now, a half-day hearing, which normally is what a setting aside application would take, within the High Court of Singapore, the cost awards are capped or taxed at about 50,000 Sing. And most times you don't even get the amount. But within the SICC, we work on the basis of reasonable costs. And that reasonable cost also depends on exactly how detailed are the cost submissions that you have. The third point is speed of proceedings. Because the High Court of Singapore has many other matters of different aspects, whereas within SICC, it's purely commercial matters. You can expect applications for setting aside, for example, to be progressed a lot faster on that. So these are three advantages. And even though you think about it, it may be a no-brainer, the significant fact about this is that actually, by the SICC being a supervisory court for IAA-related matters, you tend to discourage frivolous applications where parties most of the time tend either to delay payment of the award or to try to go fishing on grounds of denial of due process. And with that, if you think about it, my recommendation to parties most times now is to build in to the jurisdiction clause in contracts, not just, for example, arbitration seated in Singapore, SIAC rules or ICC rules, but it's next clause to say any matters arising therefrom to be with the SICC. So that way you discourage parties on the fact that it would cost their clients more and of course the proceedings would move along just as fast. Flexibility in procedures, foreign law I mentioned, rules of evidence, because we are a court of law in Singapore, by default Singapore Evidence Act applies, but parties may mutually choose to disapply that and take on a different set of rules, of which a lot of you will be familiar with the IBA rules on taking on evidence in international arbitration. So there's a sort of flexibility we allow so that parties may not feel unfamiliar in this court in terms of proceedings. Document production, we've also moved away from day one from general discovery and following along the lines of what international arbitration is about. Confidentiality, while most times people say, oh, yeah, a court of law and therefore the public gallery is open. But because we are a commercial court, we are cognizant of business sensitivities. So the threshold for application for various levels, for example, courtroom to be cleared for part of the hearing, for records to be sealed, for statements and judgments to be redacted, or even if you can prove why you require it, party name substitution. So court records, judgments will only reflect ABC versus XYZ, and not the party names. But these are things that you have to prove to a court. For example, what the court has granted is, in one of our early matters, part of the hearing involved pricing mechanisms. So a party applied for a court for the public gallery to be closed and for the records pertaining to that part of the hearing to be sealed. Because what you don't want is a competitor sitting behind in the public gallery taking notes of how you price your products or your manufacturing processes or what have you. So these are the parts that we actually provide in greater flexibility than what you would find in a normal court of law. I realize that. Okay, will do. Joiners, I've mentioned that. Costs, I've also mentioned, reasonable costs. So this is something that you wouldn't find within the SICC, within the High Court. Third-party funding is something that we've introduced recently, so that's another option that you can have for your clients. We've also introduced conditional fee arrangements, which unfortunately, I guess, addressing an Indian audience, you're not allowed to avail yourself to at this point in time. Complex matters, TIC list. I won't go into details, but the fact is that we now provide for such complex matters, especially when it can involve 20 parties with 200 contracts involved, right? So there are various protocols which I would encourage you, if need be, go onto our website, we have the details on that. And after this, NDA will make a PDF of this presentation available to you. The latest evolution for the SICC is to look at cross-border insolvency matters, where Singapore is a preferred nodal jurisdiction. So for your bankruptcy partners or associates on this one, that's something that you could look into where the SICC is concerned. Enforcement, just very quickly, 3 key pillars. We have various treaties, and India is a reciprocating territory with Singapore, so any judgments with SICC need only be registered with the courts to have the power of a local judgment. We are signatory to the Hague Convention on Trust Court Agreements, so 27 EU countries automatically included in that, together with Mexico and Montenegro. UK is one of the reciprocating territories, so you need to worry about it. But the key point about recognition enforcement of money judgments is on the right-hand pillar, which has been there for decades, preceding even your New York Convention, where courts recognize money judgments from foreign courts on 2 bases. One is that common law courts, you know that there's only a 4 basic defense of whether SICC a competent jurisdiction, whether there was fraud in arriving at the decision, whether the judgment debtor was denied natural justice, or is it against the public policy of India? If those 4 defenses don't hold, the court would recognize and enforce the judgment. For civil law courts, it's always a question of reciprocity, and a lot of the civil law jurisdictions have recognized SICC or Singapore High Court judgments. In our 7th year, in a sense, going to completing 8 years, and there's been about 100 matters before the SICC. It's slowly growing, but basically I would feel that it's a question of when it would reach a tipping point. 2 the year we started, then it's grown to 17 plus 4 last year, and this year to date is at about 17. 100 written judgments with another 25 from Court of Appeal involving 44 nationalities, claims from as low as 1.2 million to $1 billion. Our turnaround time is about 22 months, and these are only for matters that went to full trial, not including those that were settled. Decision making, judgment writing is quite fast. Okay, as fast as our record for this one is about 2 weeks from date of last hearing. Okay, and if you want to ask Justice Sikri later whether he feels pressured sometimes to ensure that judgment is done, because internally we have a sort of guideline that we wouldn't like judgments to be delayed in that sense. People don't like to lose, so we've actually had 58 notices of appeal also. And even the first appeal that was heard by the Court of Appeal took only 36 days. So very quickly, why the SICC? The fact that we have a strong DNA to ensure that matters progress, good reputation, efficient resolution of disputes, which brings you to two key points of time and cost where your clients are concerned. On the other hand, we have strong international flavor because of international judges, the flexible procedures we have, the fact that you can have counsel from anywhere in the world representing you. So therefore, I started by saying it's not a question of if or when, but an appropriate response for parties who demand transparency, open proceedings, published judgments, the right of appeal, the ability to join third parties in multi-party, multi-contract situations, and of course an access to full set of interim measures through orders of court, which you may not find in arbitration most of the time. I leave you with this slide, which is the website, because a lot of the information you would like can be found there, including model clauses, including judgments, including information on how to register a foreign lawyer. Just to give you a quick one, all our judgments are found within the website. So this is a particular judgment page. The next one would be the actual judgment with, you can see on top left, key subjects so they can do a quick search. We have a case summary too, normally about 2 to 3 pages if you want details on that. Model clauses are available there, a very simple 1-paragraph clause at contract stage. This is for post-dispute stage. And additional points if you need to put into your contracts. And this last point is something that all the in-house counsel down here should be proud of me. I've always been told I need to show this to tell you I've not given you any legal advice at all in the last few minutes that we had. So with that, thank you. If there's any issues, anything else you'd like to know, I've also left some of these brochures, which is a very concise part of it, on the reception counter outside. So please avail yourselves of that. Thank you, and I'll hand it back to you.
Before we move on, I must inform everyone that I urge you not to appoint me in hope of a reciprocal appointment. So far it has not happened. Hopefully it doesn't happen in future as well. But yeah.
Thank you, Mr. Wong. May I please request Honorable Justice Shah to address the gathering, please.
Very warm working. Can you hear me? Very warm good afternoon to all of you. Honorable Justice A.K. Sikri, former Judge of the Supreme Court of India and the present International Judge, SICC. Honorable Mr. Justice L. Nageshwar Rao, former Judge of the Supreme Court of India. Ms. May Tai, Mr. Kelvin Poon, Lawrence Wong, dear Nishith Desai, Shri Vyapak Desai, Ashish Kabra, other panelists, dear participants, ladies and gentlemen. First of all, I congratulate and thank Nishith Desai for giving the opportunity to all of us to be here and to see his imagery. It is, Vyapak has said it is not imagery, but it should be unimaginary. I entirely endorse and I agree with him. Sir, it is a privilege to be invited to address 2022 SICC conference on a very important subject, the era of international commercial court. It is an honor to have been invited to deliver an address on the very important subject. The conference is organized to discuss the advent of international commercial courts and how they offer a unique international forum for resolution of international disputes. Everybody knows the present day discourse on the need to evolve alternative dispute resolution mechanism, which tends to focus upon the large and almost unmanageable docket of litigation before courts. The rationale of ADR is perceived in terms of reducing the arrears of cases in courts. The problem of arrears has necessitated a search for alternates. The ultimate goal for justice delivery system is low cost, cost effective and timely resolution of disputes. To achieve that goal, one is required to find out the other ways. The problems which arise in the resolution disputes through litigation are well known, like delay, expense, rigidity of procedures, and a reduction in the participatory role of the parties. The business disputes, external or internal, if not resolved at initial phase, may ultimately drag the organization into a protracted court battle. The present adversary court system, litigation system, which is characterized by inordinate delays and high litigation cost, not only consumes the time and money of the parties but also potentially destroys the long-term business relations between the parties. The consistent rise of business and the trades all over the world and the accompanying commercial transactions warrant a dispute resolution mechanism which not only is cost effective but also speedy and binding. With the liberalization of economy, international commercial transactions, especially those that are private in nature, have been witnessed to grow, and in such circumstances, resolution of disputes through unconventional modes such as arbitration appears to be a preferred choice for the parties concerned. It provides the parties not only the liberty to decide the place or venue of the proceedings but in the world, but also the seat of the proceedings, which according to them serves their best interest. This mechanism means ADR and alternative dispute resolution and the arbitration disregards the usual practice and norms regarding the territorial jurisdiction and the law of land, but vests in the parties themselves the power to devise the rules which they mutually and amicably agreed to be governed by. This privilege in a very way connects the people across the world and enables the case of doing business by removing the ambiguity of application of conflicting laws. All economics rely on a staunch dispute resolution body so as to nurture international relations and improve the foreign direct investments. The commercial players all around the world explore for a place which makes the commercial disputes more viable, cost effective, binding and expeditious. These are the four pillars of the sold framework for resolution of international disputes. Object of both the Arbitration Act and the Commercial Court Act has one thing in common, that is speedy disposal. International commercial dispute resolution works on the major framework which allows minimal court interference along with having binding character. Setting up such a resolution body is in itself a profitable investment. The characteristics of the arbitration is consensus ad item. It means meeting of the minds of all the parties involved. In this phrase, the word parties thus neither includes the government nor the courts. Therefore, the courts should only intervene as per the parameters developed in the arbitration jurisprudence. Increase in international trade and investment has all increased international commercial disputes. The harmony between the two is the object which the world is trying to make. Agreement and disputes go hand in hand, and therefore there is a quest to preserve the business relationship and the commercial disputes. Pro-arbitration rulings by the Supreme Court of India during the last decade has changed the image of the arbitration of India. The increasing growth of global trade and the delay of disposal of cases in courts made it imperative to have the perception of alternative dispute resolution system. It is to be noted that under the aegis of globalization and economic liberalization, India too heavily leaned in favor of arbitration, which is considered to be the most efficacious and preferred mode of dispute resolution system. India has been dreaming to make this subcontinent as a hub of international commercial arbitration, and this dream can turn into reality only when the country will witness the multifold growth in the following three areas. Firstly, a committed judiciary to ensure least intervention in the arbitration. Secondly, the growth of world-class institutions committed to conduct as well as encourage arbitration as the best alternative to litigation for the amicable settlement of commercial disputes. And finally, an efficiently drafted legal framework within which the arbitration shall be conducted. With India being a promising destination for foreign investment, it is essential that India's arbitration law is aligned with the contemporary international practice. This minimizes the fear of prolonged litigation in case of disputes. Such a response to the changing requirement will ensure a promising future for India as a favorable destination for arbitration and can become a game changer for the progress of our economy as a developing nation. A robust arbitration regime in India would eliminate the possibility of investors having transactions in India to resort to arbitration elsewhere, since it would not only be convenient and time-saving but also inexpensive. This is a strong contention to promote and market India as a world-class facility for arbitration. Therefore, today, more and more business owners go for alternative ADR procedures like arbitration, etc., for resolving the disputes at the earliest. The arbitration is one of the widely accepted methods of dispute settlement. While settling the business dispute through arbitration, the benefits are: it is cost-effective, speedy, fairness, finality of award, simple procedure, confidentiality, and specialization. In India, like the courts, many a times the ad hoc arbitration is accused of riddled with problems of delayed proceedings, unprofessional arbitrators resulting into poor quality of award. These issues make the ad hoc arbitration vulnerable to excessive court intervention at all stages of arbitration proceedings. Why one should prefer the institutional arbitration is that it is cost-effective and time-saving. There is a discipline in the arbitration proceedings and the transparency. In the ad hoc arbitration, for a variety of reasons which may be attributed to the parties themselves or the lawyers or even many times the learned arbitrators, and no clarity and or uncertainty on the procedure to be followed, proceedings are delayed. The benefits and the major advantage of the institutional arbitration, I may tell you that in fact in every this is my personal belief, I prefer institutional arbitration rather than ad hoc arbitration for a number of reasons. The benefits and the advantages of institutional arbitrations mainly are availability of pre-established rules and procedure which assure that arbitration will get off the ground and proceed to conclusion within the time schedule. List of qualified and professional arbitrators, often proven out by the fields of expertise, are available. Appointment of arbitrators by the institution should the parties request it. Administrative assistance, physical facilities. India is relentlessly working in framing desirable policies which are compatible with the international standards and norms in order to make it one of the most desirable seats for arbitration by ensuring easy access to institutional arbitration, speedy disposal, confidentiality, etc. India is waking up to the realization that its dispute resolution system needs to keep pace with its rapid economic growth. Whilst its economy grows at an impressive rate, the Indian justice delivery system has struggled to keep pace. It is therefore but inevitable that there is a huge market demand for a speedy and effective method of dispute resolution as an alternative to litigating before the court. In recent times, the arbitration has presented itself as an efficient private sector alternate to the public justice delivery system. Various international arbitration centers across India and outside India are established, including objective of creating an independent and autonomous regime for institutionalized arbitration, which includes Singapore International Commercial Court. Singapore is widely recognized as the leading arbitration hub in Asia and the preferred base for international law firms as well as corporate counsel of multinational corporations within Southeast Asia and South Asia. Building on the success of Singapore's arbitration sector, the SICC seeks to further boost Singapore's value as a leading forum for legal services and international commercial dispute resolution, offering litigants the option of having their disputes adjudicated by a panel of experienced judges comprising of specialized commercial judges from Singapore and international judges from both civil law and the common law. I am told and I know within a very short time, Singapore has appeared as a hub of international commercial arbitration. The major reasons behind this seem to be contribution by the Supreme Court of Singapore, enforcement of foreign awards, having world-class infrastructure. Singapore prides itself in having an efficient, competent and honest judiciary. For years, Singapore has sought to position itself as a neutral venue for dispute resolution between the parties from different jurisdictions. In building upon its trusted hub status, Singapore has benefited from so many advantages. SICC serves as a companion rather than a competitor to arbitration, as it seeks to provide parties in transactional business with one more option among a suite of viable alternatives to resolve transactional commercial disputes. It enhances Singapore's success as a seat of international arbitration as well as international recognition and acclaim enjoyed by the SICC and SIAC. In India, both the ad hoc and institutional arbitration prevalent. It cannot be disputed that in terms of cost effective benefit, expediency, efficiency and hassle-free mechanism for dispute resolution, the institutional arbitration has its edges. The ultimate aim and goal in arbitration center would be cost-effective and speedy resolution of the commercial dispute. I hope and trust that such conference, conference like today's conference, will give a boost to the international institutional arbitration. In today's conference, the respective panelists, a very senior panelists like Justice A.K. Sikri, Justice A.L.N. Nageswara Rao and other panelists would discuss on different aspects and from different angles, which will ultimately give a boost to the international commercial arbitration. Once again, I am thankful to the organizer, more particularly the Nishith Desai, who says because of his insistence, correct, I am here, because every time, correct, he was saying, sir, first, come. I cannot resist to say no to him. Maybe because of we belong to the same area, means Gujarat and Gujarati.
Thank you, sir.
I am thankful to not only Nishith Desai, but Mrs. Desai also, both his son and the daughter also, for this warmth and the hospitality which they have shown, correct, and the wonderful experience which they have given to me, and they have made it not only my day, correct, by my month, I can very well say to them. Thank you very much. Wish you all the success. God bless you, all of you. Thank you.
We now move on to the panel discussion. The topic of discussion is International Commercial Court as an option for resolution of international disputes. May I request Mr. Vyapak and Mr. Ashish to please take it forward and moderate this discussion.
Yes, thank you, Shraddha, and thank you, Justice Shah and Lawrence, for such a great setup. So straight away we'll go into questions. We have heard a lot about what we want to talk about, but I think listening from people on the panel would be the best. So Justice Sikri, straight away to you, because I think you are the only connection between us and SICC. You are the international judge there and you know us well. So I think if you can share your experience as an international judge on the SICC court, and how would you distinguish it in terms of good and bad points as to national courts, international courts, and your experience through?
Thank you, Vyapak, for this question. And as you have asked me to give my experience as international judge in SICC, and related question is about the traditional national courts and the international courts. Let me start with the second aspect, and then I'll come to my experience. This as the topic of today's conference is also era of international commercial courts. Now we know it, and if I may tell you from my experience, practicing as a lawyer, I joined profession in 1977, became judge of the High Court in 1999, so 22 years of profession. I had a lot of arbitration matters as well, but most of this, and I hardly had done any international arbitration in those days. Things changed after 1990, and of course by the time as India ushered into globalization, and there was a lot of, as we have been talking about, FDI and lot of collaborations, technical and other collaborations, and which gave rise to, as Justice Shah has also pointed out, the disputes, and which have the international ramification, and therefore international arbitration also rose. Not that it was not there at that time also, but then when I demitted the office, of course, as judge, in the beginning, in the Delhi High Court, I would see only domestic arbitrations, but towards end, many international arbitration and disputes, and particularly enforcement, etc., to judge the arbitration award or even foreign judgment on the touchstone of Section 13, etc., of CPC. These I had started doing that. I remember in 2004 or 5, one SIAC case came, and at that time when Bhartiya International was
a big
issue, and I still remember how I just made a way out and still said that how SIAC would have the jurisdiction to deal with interim measure also. But what I am trying to say here is that with international arbitration, what I want to point out is that there are 2 or 3 unique features which came. We have Section 20 CPC. Now, which talks about the jurisdiction of the courts, and it very clearly says that where the cause of action arises or where defendant resides. Cause of action or the part of cause of action. And we have the clear rule that if a court lacks inherent jurisdiction, even the consent of parties cannot confer jurisdiction. There is a complete departure to this principle when it comes to arbitrations. And interestingly, our own Supreme Court has given a judgment that even two Indians today, they can choose foreign jurisdiction. So this is one thing when we talk of party autonomy in arbitration, we also talk of even the autonomy or choosing the jurisdiction also. Whether, yes, we want to go to SICC or we want to go to any other LCIA or ICC, etc., we are permitted to do that. And secondly, this, as I said, neutral jurisdiction. Now, it was, the international arbitration has mushroomed because of that. But over a period of time, what is now coming is that as we now say, era of international commercial courts, there may be some areas, Lawrence has said in detail about it and I don't want to repeat that, some areas where the parties may, it is an international dispute, but they may still like to go to the court instead of arbitration. We have in India, for domestic, our Commercial Court Act is there. So parties can still go to commercial court in India for domestic arbitrations. So likewise, it gave rise to this phenomena of establishing international courts. And many countries have done so. And interestingly, actually, it started with the special economic zones, which were in Gulf region. And it is a proliferation of that, and which spread in Asia and Europe, etc. And many countries started establishing international courts. Now, two or three things between the international arbitration and international courts, which are distinguishing features, are that I have seen in last three and a half years after demitting office and doing many international commercial arbitrations and domestic arbitrations, many times retired judges or even brilliant lawyers who write exceptionally good awards, but it has no precedential value. There is no growth in law as such with arbitration, except when the matter is challenged, and then the judgment of the court comes in the form by upholding the award, etc. But there are many complex issues which arise where party autonomy should remain, the neutrality should remain, as I said, that parties may, but then there may be more faith in the court. So this is where it comes. And of course, as I have said, there are few, and now I am quoting one author. He has written a beautiful article, and rather one book has also come on this international commercial courts. But not that I am international judge of SICC, that is why I am saying so. He says that truly today, if there is one court which has got the international commercial court status, that is SICC. He has compared it with many other courts, and the example which he gives is that many jurisdictions, many countries or the governments, he calls it international enclaves. So they are international enclaves in their mother jurisdiction. They call it international but may not be having that international status. So what distinguishes, which Lawrence has said, and I'm now coming to your second aspect of the question, my experience. What distinguishes is that it's a truly international character with international judges. And as he rightly pointed out, the judges who are chosen have expertise in different fields. And therefore, international commercial courts, it becomes in a particular case where the parties think that we don't have to go through the route of arbitration, but we want to go to a court. And they want to choose a neutral court, like neutral arbitration, number one, and where there would be truly international character, and the expertise of the judges would be there, that there the SICC really shines and overshines in comparison with others. And two things which I have seen, witnessed, there are two ways of the way in which SICC is doing, and I would not say it in detail, but as Lawrence has mentioned. Number one is that now parties may choose, even when arbitration award comes from SIAC and award is challenged, instead of going to the national court, they can go to SIC route. Now, advantage or otherwise, they can straight away think of, if there is no arbitration, but then the parties may agree to have a matter litigated, as it is said that the SICC is the adjunct of or division of High Court of Singapore. Now, what happens, I have done one case in that level, mostly Court of Appeal, where I have sat in appeal, and I had the experience, I have seen the issues which are arising are really not only complex, but commercial issues which have tendency to develop law. And the judgments which are given, and the normally the quorum, of course, Chief Justice sets the benches, he fixes the benches, and normally there is one judge from Singapore, two other judges would be from other jurisdictions. So it's a combination where the three judges from three different jurisdictions, their own experience in that field and the way it is contributed, and we ensure, as Lawrence said, that the judgment should come as early as possible in that sense. But on personal level, I would say that it has been an enriching experience, because true professionalism, which I have seen, the CMC in the manner in which it takes place, and we were just, although with Mr. Kama, I was just talking before, in the context of arbitration, which is imbibed by SICC as well, that before this CMC would be there, they would ask how much time it would be taken. If it's a court of appeal, it's only an appeal. But then they stick to those timings, they stick to those dates, and judgment pronounced as far as appeals are concerned within 6 months to 1 year, I think that happens. And even like our section 34, if from SIAC they want to challenge and it is assigned to SICC, then that also within 1 or 1.5 years, the case is decided. So enforcement of the, or at least the, challenge to that arbitration award is decided one way or the other. And the good thing which international commercial courts have is that I have, this is my experience, and lawyers, you people know better. Many times what happens, arbitral tribunal, of course, is a party autonomy. The challenge is on very, very limited grounds and not on merits at all. So therefore, many times, although the arbitral tribunal is the creature of the contract and the parties have, so the arbitral tribunal has to decide in terms of the contract. But many times on the interpretation of particular clauses, etc., parties are not very happy from the outcome. And they think that it has not gone well. But then that cannot be challenged.
There is no appeal.
That is why in many complex cases of such nature, international commercial courts become preferred choice, because you can have a second bite on the cherry. Like in the domestic jurisdiction, you have the appeals. So there, if it is decided by SICC, so Court of Appeal, as was pointed out, it is there. So therefore, all these are really good experiences, and it's in a totally different world altogether, where today I have done domestic arbitrations, I have done international arbitrations, and I have sat in international commercial courts as well. It has been quite a
journey,
fulfilling experience for me. Thank you.
Thank you.
Yeah, so let me bring in Justice Rao over here. I think the points which have come up, and Lawrence thankfully ran through that slide quickly at the start, so I can take this up again, and Justice Sikri has been alluding to, or has been referring to, it's the difference between arbitration and the process in an international commercial court. Some of the points I've already discussed, like the development of law and the role of precedent as we move forward. But I would bring in Justice Rao over here to see what, in his view, are some of the better or the important sort of differences or differentiations, why it makes it important for parties to think of international commercial courts as opposed to arbitration.
Yeah, good afternoon. At the outset, I should apologize to all of you for not being present there and just recovering from a severe bout of cough. and on doctor's advice, I haven't traveled. Justice Sikri, Justice Shah, I miss being with you. I thought I'll spend 2 days with you there in Mumbai. A chance I don't get in Delhi. And I missed an opportunity of meeting Lawrence Wong and Kelvin Poo, who are there. And good afternoon to May Tai and Nishith Desai and Vyapak Desai. Thank you very much for giving me this opportunity of speaking to you. And good afternoon to all the persons who are present there, as well as persons who are viewing this seminar virtually. A presentation by Mr. Wong and the speech of Mr. Justice Shah and the answer given by Justice Sikri to the question posed to him makes my job very easy. They have covered what all has to be said by me. The advantages of Singapore International Commercial Court has been vividly explained by Mr. Wong, and the importance of arbitration has been spoken to by Justice Shah. And while giving his own experience as a judge, international judge of the Singapore International Commercial Court, Justice Sikri was trying to balance both and the occasions which parties take advantage of to approach the Singapore International Commercial Court. But in any event, I'll give a short response to the question that is posed by Ashish. Arbitration is the primary method of resolving international disputes. It has already been said, and all of you know, that arbitration dominates the field because of neutrality, confidentiality, party autonomy, procedural flexibility, worldwide enforcement, choice of arbitrators, and finality. However, there are certain deficiencies in arbitration, which are high costs, long delays, allegation of overcommitment of experienced arbitrators, and the inability of including third parties in multi-party disputes, and limitation of inarbitrability of some disputes, especially those concerning special torts arising from contracts, international intellectual property disputes that relate to validity of trademarks, patents and designs, and trust disputes. There's also a problem of conflict of laws, because there can be different laws that are attached to the arbitration agreement, parties' legal capacity, the arbitral procedure itself, supervisory and enforcement measures, and parties' substantive rights, remedies, etc., where there is a question of conflict of laws that might arise. The international commercial courts, which have proliferated recently, especially in the Asia region, claim unrestricted subject matter jurisdiction and their ability to join third parties and avoid conflict of laws issues. And also, the international commercial courts overcome the deficiencies relating to over-formalization, delays, rising costs, lack of consistency, absence of appeals, and concerns about legitimacy and ethical issues. Now, when we have to compare the international commercial courts with arbitrations, let us take 4 main issues that arise from this discussion. The strength of arbitration lies in party autonomy, where the parties are at liberty to choose their arbitrators and also to choose the substantive laws and arbitral rules which govern the dispute. Now, that can't be done in a dispute before the commercial courts. But the Singapore International Commercial Court, as Mr. Wong was explaining, has also tried to balance this party autonomy by permitting substantive laws to be chosen by the parties and applying them after an order is passed by the court. And even rules of evidence need not be the Singapore rules, but the parties can agree on rules which are governing their own jurisdictions. And foreign lawyers are permitted to appear in offshore disputes as well. Insofar as the second aspect pertaining to confidentiality, which is also a very important attribute of arbitration, courts normally operate publicly. Take the case of DIFC, where hearings are public. But insofar as SICC is concerned, there is an offer that is given to the parties in offshore disputes where confidentiality can be maintained. But ultimately, again, it's a discretion of the court to permit confidentiality or not on the application made by parties. And the third aspect that comes to my mind is finality. The finality of awards passed by the arbitrator with limited grounds of judicial review is an advantage in arbitration, and there being no appeals. But insofar as international commercial courts are concerned, there are appeals against orders passed or decisions taken by the commercial courts. SICC again makes an adjustment here. Though there is an appeal to the Court of Appeal, parties can agree that the decision of SICC can be final and they can limit or waive or vary their right to appeal in writing. And the last issue is pertaining to enforcement. Arbitrations have an advantage in themselves because of the enforceability of the awards that are passed by international arbitrators in commercial disputes, as according to the New York Convention, there is enforcement of arbitral awards in about 162 jurisdictions, and it becomes easy to enforce the awards when it comes to international commercial courts and the decisions taken by them. The enforcement is on the basis of regional and bilateral agreements for enforcement. SICC has agreement with about 11 countries. Singapore has also signed the Hague Choice of Court Convention in 2005, whereas DIFC has followed a peculiar method of converting its decisions into arbitral awards so that they can be enforced under the New York Convention. So look at these four aspects which I just mentioned. If I can compare the functioning or the ease of decision making in international commercial disputes between the international commercial courts and arbitrations, I'm of the view that both have their own strengths, except for those disputes which cannot be decided by arbitrations. Arbitration would continue to be the primary mode of dispute resolution.
Sure. Thank you, sir. I think that puts it really well. But let me bring May in over here, because we've been hearing from judges so far and very nicely. But May, now probably a practitioner's perspective on what is your take, whether what Justice Rao last said, that arbitration will work in tandem with the international courts. And in terms of your experience, what are the frustrations that you have seen on actual cases that you would like to share with us?
Ashish, and thanks everyone first for inviting me to attend this conference with such esteemed panelists whose comments thus far I wholeheartedly agree with. By way of background, I need to disclose first that I am first and foremost an arbitration practitioner, so probably will come in with comments wearing that lens. But having said that, I have had a case in the SICC as well as dabble in some parallel litigation where a dispute ends up breaking off into different proceedings, some in arbitration and some in litigation, which is why I did love the comment made by Justice Shah that the two, arbitration and litigation, and international commercial court litigation in particular, should be seen as companions rather than competitors. Because indeed, I believe what others have said, that there are advantages and disadvantages to each one, and therefore having both be available to users, to disputants, is very important. I guess in terms of the weaknesses of arbitrations, while I agree with what Justice Rao just said, that the strength of arbitration, lies very much in party autonomy, sometimes party autonomy is also arbitration's weakness, And what I mean by that is that tribunals can be too focused on honoring the party's consensus and party autonomy, rather than, in my experience, a judge would be more pragmatic and efficient and try to move the parties forwards. In arbitration, there's a lot of due process paranoia that leads to additional rounds of submissions, additional hearings, additional audiences with the parties, just to avoid one or the other party complaining about fairness. The lack of sanctions and penalties that the tribunal has to dissuade parties from behaving badly and trying to delay the proceedings is also one of the weaknesses of arbitration. And finally, something that both Lawrence and Justice Sikri has mentioned, the inability to create jurisprudence, which is very, very helpful for parties who have multiple disputes about similar issues. That is one of the downsides of arbitration. Maybe I will just pause there before everyone's turned off arbitration.
Yeah, let me take this away from there and bring Kelvin in. Kelvin, you are our Singapore
very patiently listening.
You are our Singapore counsel on the panel. So coming from that perspective and going specifically to more procedural aspect, in India, our commercial courts are governed by CPC as amended by the Commercial Courts Act and have an own set of specialized processes. Similarly, we heard Lawrence earlier talk about the SICC rules 2021 came in from last year, 1st April 2021, became effective from that date, having some specialized features. You are the practitioner. How would you say, how special are they actually?
I would say this. Can you all hear me well?
Yep.
Yes. I think we've heard a lot from Lawrence and everyone else on the panel on all the features of the SICC process. Maybe I'd like to boil it down to maybe 3 key characteristics that makes it special. The first is hybridization. Second is internationalization. And 3 is party autonomy. I'll start with the last one. Because we are so used to thinking about how arbitration is the champion of party autonomy, and so we think of litigation as being the opposite of party autonomy. But SICC has sort of reversed that. It's challenged us to think carefully about what we say about party autonomy and ask ourselves the question, does it mean that just because you're in court, the court cannot respect party's choice? So I give one example, right? We have the right of appeal in SICC. But the parties have a right to choose not to have the right as well. Again, right? I mean, of course, there's a lot of value in having a third, another tribunal above the first instance court to review the merits of the decision. But if the parties value speed and finality over the final review of the decision, then the court will respect that choice. So party autonomy trumps in that sense. It strikes the right balance between the need to respect parties' interests and the public interest in open litigation. So that's the third one. Maybe I'll go to hybridization. Again, this is another special facet of SICC, where we try to pick the best of both worlds in international arbitration and the court and put it in one melting pot to come out with a nice curry. Right? You look at this issue about evidence. All of us here who are either counsel or clients, we are aware of the difficulties sometimes we face with documents and the dreaded hearsay rules. How often have we got the chance we're going to prove some damage and we're going to produce some document made by some employee 7 years ago who has left, and we say, what are we going to do with this? The fact that you can choose to opt out of the Singapore rules of evidence, as well as the hearsay rules, and to replace it perhaps with the IBA guidelines, gives you that flexibility to pick the sort of procedural rules that will help parties resolve the cases fairly and cheaply, effectively. You don't have to go around the world hunting for this one elusive witness and to get him to speak to this document, or maybe 3 documents. The same thing applies for discovery of documents. In our system, I'm not sure what the system is in India, but in the Singapore system, it used to be that you have an obligation to produce both the documents that help you and the documents that hurt you. under the SICC rules, you can displace that. And the rules in SICC now says all we have to do is to produce the documents at the outset that you rely on. That again is an issue of hybridization, because that's really taking the IEBA rules on taking of evidence and plonking it into the court process. Again, picking the best of both worlds and giving out a solution that helps users. And I suppose the last point I'm going to say is about internationalization of SICC. I mean, we have heard so much about how there are foreign judges, there are foreign lawyers, but these are very useful for the client, because there's a very peculiar rule in our common law system about how foreign law is proved as a fact. So if you do not raise a specific point of fact on foreign law, it is usually assumed in the Singapore context that Singapore law applies. So what happens if I'm silent on principles A and B of foreign law, but I take issue with principle C of the foreign law? And when you then amalgamate A, B, and C together, you get a law that's actually neither foreign nor Singaporean. It doesn't really work. So the option of getting a foreign lawyer in to come in and speak to what the law is, and for the judges to take it as a matter of judicial notice and to come to a decision, makes sense for everyone. And the last point I'll say before I drop off is this, and this last aspect I think is crucial, and it's a point that I think everyone has said so far already, which is the value of an open decision on a point of international commercial law. It is a fact that may not be of great value to the immediate disputants. They only want the result. But for the broader commercial community, it makes a big, big difference that you have many learned minds of counsel, of judges coming together to grapple with the contemporary and difficult issues of commercial law, and having passed as a judgment goes a long way towards forming this thing called lex mercatoria. I think we've heard of that term many times before in the past. And we ask ourselves, what is lex mercatoria? I'd like to think that the formation of SICC and the judgments that will flow from it are an important first step in that direction. That's all.
It's interesting. I think some of the things that you said are similar, but in a truly international context, and Singapore as a hub, it deals with a lot of civil law countries. And for them to come and choose a court which is now going to adopt a common law rules of evidence is going to be very strange. So there, yes, particularly the choice of SICC becomes very apt. Because you made another point over here on development of lex mercatoria, and we are talking about it again and again. So let me throw a more sort of a different question over here to our panelists, that given that you are trying to attract civil law lawyers to come to SICC, you are giving them a chance of representation in court. They don't have any value, they don't look at precedent. The precedent has no value. So how would you, probably sir, sitting as a judge on the SICC, or how would you, Kelvin, practicing at the SICC or appearing there as a Singapore lawyer, or Meta yourself or everybody, use that judgment before the court? Would you say it is binding on the court? Or would you say it is persuasive value? How would you use that judgment?
You see, it's a very interesting question, and those practical problems or challenges, I would say, as well. But let me start with one thing before that. Very interestingly, which I see in civil jurisdictions also, this phenomena, that you will find judgments there also. Of course, they write judgments. Yes, unlike common law, they are not cited as precedents, but many times they are cited as precedents also, but not as binding precedents. So what I have witnessed in last number of years, that first of all, the difference or distinction between common law and civil law is blurring. I have seen, I remember while sitting in Constitution bench in the Supreme Court, because when there are constitutional issues, and Indian Supreme Court that way with the open heart and accepts the jurisprudence from other countries, and if there are good practices or good judgments, we follow that. And in one case, I remember a very interesting jurisprudence created by German court, which is a civil law country otherwise, and which is cited in law, because it's a constitutional issue, so I'm not discussing that in detail, not a commercial issue. But I gathered from there that even now in civil law countries also, the judgments are cited, which theoretically speaking may have persuasive value, but almost are accepted as binding precedents and are followed in subsequent judgments. So therefore, this peculiar feature many times does not create much of a problem when in their own jurisdiction, civil law jurisdiction, if there is a judgment which is cited and if they have also followed it in subsequent judgments. And once or twice it has happened sitting in SICC here, when we asked the parties, then good thing was the parties readily agreed that it can be cited as a precedent, because interesting thing which is happening is that as you also mentioned, and Lex Mercatoria, which is I mean, this kind of jurisprudence which is developing, it's a new international commercial law jurisprudence which is being created, which is the combination of both civil law and other, which is happening even in, I have seen from my experience when the judgments are cited, even in commercial arbitrations as well. But the only difference in commercial arbitrations, the award is not even known to the parties. So even if it is accepted and even if it is done, it is not known. Whereas here the jurisprudence is created by a judgment which is not only becomes a, particularly sitting in Singapore, which is a common law country, not only becomes a precedent for future, and where some judgments of other countries which are civil jurisdiction countries are taken. And that is what gives SICC a unique character. Because here not only the judges, international judges are from both the jurisdiction, parties may also come from both the jurisdiction, and in international arbitrations and international disputes, it is always possible, and mostly it is there, that one party may be from common law jurisdiction, say India dispute with France, company in France or company in Germany, etc. So the two parties may be of different. So they may, this one thing which is taken care of is that this problem is resolved by giving parties the choice what kind of evidential rules, etc. you want, what kind of even the law of which substantive country you want. So on that basis. But particularly what I feel is, and the Singapore may become really a torch bearer in that sense, by creating this kind of jurisprudence. A new jurisprudence may come out with some very, very interesting principles of law which may emerge with the adoption of both sides.
I know Lawrence was talking about a crypto dispute now pending before the SICC, so we look forward to that jurisprudence as well.
So let me take a little different, I think bar and the bench has been talking a lot, and I think ultimately the users, whether they want to go to national courts, whether they want to go to arbitration, whether they want to go to international courts, and we have like Siddharth from Tata, I'm sure he would be going through these questions. We have Atul, we have Nivya here with Ravi and Santek and everyone here. I think they must be all possibly grappling with these questions, right? What kind of dispute resolution you should adopt? So what kind of contracts and disputes are suited for international commercial courts? Maybe May, you want to come in first, and then maybe Kelvin can chip in.
Sure. I think because, whether you call it precedential value or just a publicly available judgment, it does impact on the industry and what the industry will consider the standard bearer on a particular interpretation of a dispute or contract issue. I think this benefit of going to the international courts means that it's particularly helpful for example, insurance or reinsurance, banking and financial markets, crypto, as Lawrence says, because this will lead to a lot of class action type disputes over very, very similar issues, commodities, shipping. All of this is very helpful. And I did want us to say 1 minute about the previous question. I agree with Justice Sikri in terms of what happens even in the civil law countries, because although I'm based in Hong Kong, I obviously have a lot to deal with the Chinese courts. And that's exactly how they do it. The higher courts will publish their decisions, and although there is no binding precedent, there's no such concepts, once the, two or more higher courts reach a similar view, then the rest of us users and clients can accept that this is what the law should say, even if it doesn't say it in statutes, and how the courts in the future will decide that particular issue. So it is very helpful, notwithstanding there not being a precedent.
So Kelvin, what do they choose, and why? What kind of contracts?
I think it's fair to say the most important question probably at the start is ask ourselves, who is your counterparty, and whether there's any issue with enforcement. I mean, once you get past that first hurdle, and I think we have heard already a lot about how court judgments are actually enforceable across many jurisdictions. Once you get past that first hurdle, you will find that most contracts are amenable to a court determination. In fact, in some cases, maybe it's even more important. So maybe I give two examples where I think it's very useful. The first actually is construction. In the past, you'll say construction is not so useful because you say courts can't understand construction concepts, problems with expert witnesses. But there's one area where I think construction law can benefit a lot is in FIDIC contracts. So many FIDIC contracts are at play, but so many go for arbitrations. And as a result, the development of the law is not always coherent. It could be more coherent if there was more public exposition of the discussion on these points. And second, for construction contracts, the multi-party nature of a single project makes actually a court proceeding far more useful, I think, in that way. You can just draw parties into a single set of proceedings. The second area which I thought was useful is in the area of finance contracts. Because usually when you're dealing with standard forms or special concepts relevant to securities or the interpretation of various clauses, you want to have binding value, or at least a published precedential value that will guide parties or the industry going forward. So again, I think judgment of the court in those situations will be useful.
Sure. Right, so now we have discussed all the benefits, but Lawrence, we need to come to this part as well. The grass cannot be so green on this side, right? So what about the challenges? At least there have got to be some challenges in also dealing with commercial courts. So May, what are your views? I think Kelvin just alluded to one aspect of it, but from a different perspective while negotiating contract, how you choose, but on a similar point. So coming to you, what challenges do you see in the adoption or growth of commercial courts? And connected to that, I'll give you another question, is how are commercial courts actually working today to improve their acceptance and how their user base is growing?
And maybe Mr. Rao can cover.
One that Kelvin and others have said already, which is recognition and enforcement. I think that's arbitration still has very much the upper hand there, with the New York Convention basically covering, practically the whole world. Whereas if you're choosing to go to court, you're still relying on a lot of bilateral instruments. And although the Hague Convention is getting bigger and bigger, compared to the New York Convention, it's still very, very, very small, and it will take some time before it gets bigger. I definitely think with panels like this and people like Lawrence at the helm of the international commercial courts, we will definitely get there in time. But in the meantime, as Kelvin said, unless you're very clear that where you're seeking to enforce is somewhere with some sort of bilateral or multilateral arrangement, it's still quite arduous and uncertain. And the same concern about enforcement of a judgment will apply equally for the moment to enforceability of interim measures. And the last challenge that I will mention is the point about interpretation of domestic laws. We will still have teething problems, I believe, with an international commercial court, how it interprets foreign law and the the actual local courts themselves interpreting their own law, and that could lead to a few conflicts in decisions that we will have to work through. So, just to give you a classic example that comes from arbitration, there's the very famous Dala litigation about whether parties, certain non-signatory parties, should be parties to an arbitration, and that was the French court and the English court came to diametrically oppose views about the same legal question. So we may have some of that, and it may take some time to work through as between the national courts and the international courts looking at similar issues.
Yeah. Mr. Rao, if you have any thoughts on challenges, I think you have already given a note on the advantages, but I guess, are there any challenges for international commercial courts? If at all you have any thoughts.
International commercial courts as of now lies in there being no uniformity and harmony in the rules. That's one aspect I think which would come up. The proliferation of international commercial courts and they having their own rules, there is no uniformity. That's one aspect which can be also looked into. But to start with, when I was answering the first question posed by you about the challenges that are faced by the international commercial courts pertain to certain issues which are advantageous in arbitrations not being available in international commercial courts, though there is some sort of an adjustment that is made by Singapore International Commercial Courts. You look into the other international commercial courts, they might be a little rigid for a consumer of arbitration rather. If a person wants an international commercial dispute to be settled, he would first be thinking about confidentiality first, and thereafter party autonomy, and also enforceability. Enforceability, according to me, is a major issue now when arbitration awards can be enforced in about 162 countries because of the New York Convention. Even now, the Singapore International Commercial Court's decision can be enforced only on the basis of a bilateral agreement. And as I said, that it has only agreement with about 11 countries. These are certain challenges which definitely with passing time, there will be answers that will be provided.
Sure.
I think
so. We do have few questions.
Yeah, no, one area I'd just like to add a point over here, and which is not necessarily a challenge but could be advantageous depending on how people view it. That is the distinction between the test for recognition of a foreign award as opposed to the test applied for enforcement of a foreign judgment in India. So in case of foreign judgment, any breach of law or any judgment founded on a breach of Indian law can be challenged. But that distinction has been removed away, or at least to the extent that law does not give rise to a level that is fundamental policy of Indian law, so to say, it will still be recognized in an arbitration context. So all those disputes, at least on the private equity side, with foreign exchange management law, Foreign Exchange Management Act issues which were differently treated in arbitration, may, depending upon how the initial judgment goes, could have a different impact if brought to be in India for enforcement. But again, depends on where you are, how you are representing, there can be such differences.
So, yeah, we have few questions as we have jotted down, but anything from participants here, because I guess you guys have listening for 2 hours. Yeah, Karishma.
Thank you. Continuing on challenges, I think one of the greatest challenges that any international court, including an international commercial court, faces is service on foreign parties. I think by its very nature, an international commercial court is going to attract foreign parties to it. I noticed that the manner in which jurisdiction is conferred on the SICC is by an opt-in clause in the agreement itself, which is a little bit like arbitration. This is quite different from, for example, the DIFC court in Dubai, where so long as there is any party to the matter that has an office within the DIFC jurisdiction, the jurisdiction is automatically conferred on the court, which makes it rather easy as far as service is concerned. So perhaps Lawrence can answer this question. And the second, I think one of the greatest advantages is also the enforceability of interim injunctions. So does the SICC grant worldwide freezing injunctions, which might be one of the greatest advantages for Indian parties?
Okay.
You can speak.
Yes. Can I?
Yeah,
okay.
It's on.
Now, remember that I mentioned earlier that the SICC is a division of Singapore High Court. So it has the same powers as if those orders were issued by the High Court itself. And onto your first point, it's as effective and as ineffective as something coming out of international arbitration in a sense. You need, I acknowledge that you need to serve the order properly on a foreign party, okay, and thereafter for the foreign party to actually agree to appear. However, we've had matters before for the Singapore High Court on default judgments where order was served, party was given the right of reply but chose not to, and then a default judgment was granted, and that default judgment was brought back. And I have examples from Japan as well as Vietnam to the courts down there, and the judgment debtor tried to resist it in those courts, and it was actually recognized and enforced. And you notice the two examples I gave were actually civil law jurisdictions, but the same questions were asked. Were you properly notified? Number one. After that, were you given the right to respond? Yes. And you chose not to reply. The answer was yes. So it wasn't an issue against public policy of whether it was Japan or Vietnam in those cases, and therefore at least that one, it proves that it is enforceable in those things. In terms of Mareva injunctions that you brought up, again, the similarities, Mareva injunction issued by Singapore High Court has been enforced worldwide in a sense.
Kelvin, if you would like to also.
Maybe you could just address a point that Karishma made about service. I think the distinction between the DIFC and SICC is brought into sharp focus with that question. Because the DIFC is really a domestic international court, in the sense that it's meant to address an international audience within a certain financial center within Dubai. So naturally the service issues are easier to manage. But SICC, I think, recognized this. So as a result of that, I think there's a difference in the way SICC treats service of process out of jurisdiction than the regular Singapore court. In the regular Singapore court, if I were to serve a writ out of Singapore overseas, I need to get permission first, satisfying convenient forum, etc. In the SICC, once you have a jurisdiction founded on agreement, the right to serve out of jurisdiction is assumed. And the court can, and the party can straight away serve it on the foreign party without the need for leave to be granted. So again, that's yet another facet in which you've seen how the SICC gives a lot of weight to party autonomy and to just help party achieve an international way of quickly resolving disputes. I hope I addressed that question.
Yeah, Nandakumar.
Very sure I'm loud enough, but...
You can also introduce yourself. He's a senior advocate from Bangalore.
I'm Nandakumar. I'm a senior advocate based out of Bangalore. Thank you for the extremely enriching session. We are now seeing in the last few years, Indian commercial courts, for example, are doing extraordinarily well. In Bangalore, we have a disposal rate where matters from the time of filing to the time of disposal are less than a year and a half. And then you straight away go on appeal to the division bench of the High Court, which is perhaps comparable, if not better, than what arbitration does. Now, I know Justice Sikri, when he was in the Delhi High Court, brought in a lot of, and the other judges there, brought in a lot of international best practices into the Delhi High Court's commercial practice even before international arbitration practitioners could bring that into India. Now, basically, you're seeing, well, to borrow the theme from Justice Shah, not necessarily a competition, but a good, healthy rivalry between arbitration and commercial courts on the other hand. The counterpoint is that if there is constant change in how commercial courts or arbitration functions, then investors or companies also get unsettled because they feel there's a constant change in the law. How do you think you should balance the need for constant reflection between, well, if not competitors, your collaborators, and the changing scenario in business, and the need for constancy that business communities feel? How do you think, from having been in the Supreme Court, you'd see that that balance be maintained, sir?
You see, I think ultimately, as Kevin has also said, the parameters which are to be kept in mind while deciding whether one should go for arbitration or should go for this commercial court. It would depend upon the nature of each case and the interests and stakes of the parties concerned. The two should act in unison and not, as you rightly said, even if rivalry, it should be treated as healthy rivalry. But I don't even think it as there should be any rivalry. They are in unison, and rather they should complement each other. That should be the ideal situation. And the decision is left to the parties, because once we talk of party autonomy, and here you see, normally if we see, we have the courts in every court in every country, and justice is a sovereign function. So therefore it is the state's responsibility. And here in commercial cases, and particularly international commercial disputes, we are talking it as I said earlier, also a sort of exception to that, where the parties are choosing. So once the parties are choosing, and as I said that even two Indian parties now, Indian Supreme Court has said, can go to foreign jurisdiction and choose that. So therefore it is for the parties may have to decide. There would be so many factors which are we have just discussed. It is cost also, it is enforceability as well, whether the parties want consistency, as it was said by May, and I think Kelvin also said that, look, sometimes they want consistency if there's one party may have various disputes of similar kind. And in India we have seen many times a particular public sector undertaking. So because these are standard format contract, and it may have entered into such contracts, a construction contract with so many companies, say NHAI must have done similar contract with so many, but they won't like that this is interpreted in one by one arbitral tribunal in one way, other arbitral tribunal in another way, and there is a conflict of decisions. So as a party, yes, these are not decisions, these are different awards, but then a party may not like such a situation, that on a similar question, we are in one case, arbitrators are saying we don't have to pay anything, another case says no, we have a huge liability. So maybe in such circumstances, they may like to have consistency, and they may go for court option, where the decision would be not only the judges who are deciding and it has precedential value, but then it would be binding as well, in that not between parties as such, but otherwise as well. And as Mary very rightly said, and this is my experience also, many times in arbitration, the particular party which has nominated, sometimes they think, they may not be, I'm not having any adverse comments on the arbitrators as such. I'm myself an arbitrator. and we judges are trained in a different manner. Whosoever has appointed, we will like to be objective, we will like to be neutral, etc. But it is my experience also sometimes that a particular nominee, ultimately when it comes to resolution of disputes, may even go what should be the decision or fair resolution, but sometimes may have some inclination towards the party which has appointed, etc. And this is the issue which is not only in domestic arbitration but international arbitrations as well. And therefore here if that is the concern of a particular party in a particular case, this is what I am saying, they may choose to have. So these may be various considerations. So arbitration is good, so are the commercial courts. Both have their advantages, etc. Both have their challenges. We are not discussing challenges. So therefore the two parties who are litigating parties have a choice, and they can consider all these aspects and ultimately think that where they should go.
I think there's one maybe last question from Shrivals Kumar. We have a high tea outside, everyone would be here. Only thing, Mr. Shah has to leave at 4:30, but we'll continue for a little more time. But maybe Shrivals, you can have that question because we also want to thank him before he leaves.
Yeah. Thank you so much. I think we should appreciate for the august panels to give us so much of insights. My name is Srivals Kumar. I've been a general counsel for over 2 decades. My only question is, I think we got a good of data about how many cases has been successful in a timeline. Could Lawrence also throw some light on how much has been the enforcement and the successful party has been able to get its money or rights on the ground? What time that usually takes would be nice guidance. Thank you.
I need to answer that in the negative, in the sense that we've not had any responses back that our judgments were not enforced. Specifically where the SICC is concerned. But then if you move back to a broader base, again, I allude to the fact that because we're a division of the High Court, we've not had much feedback on the non-recognition enforceability of Singapore judges in any of the other foreign jurisdictions at this point in time. In the interest of openness, it is more 2 countries I need to point out. One is Indonesia, the other one is Thailand. Indonesia still follows the old Dutch code, which doesn't recognize foreign judgments, even though the Netherlands themselves has reinterpreted that code long ago, right? So for that one, whatever money judgments out of Singapore or any other jurisdiction will not be recognized by the Indonesian courts. Thailand also adopts the same principle. If you want, you need to relitigate the entire issue before the Thai courts. But again, having said that, the smart parties, if they choose to want to do so, and I take the example from the Commercial Court in London, your Russian parties in the past. You find that there were a lot of Russian parties before Commercial Court in London because they were never ever looking at enforcing against assets in Russia, but against assets that the
outside Russia or somewhere where UK will be.
So even for Indonesian companies, there are lots of assets everywhere else, especially in Singapore. So that's why you even find litigation in Singapore.
I know. Find your assets somewhere else. I think maybe I'll just check with Justice Rao and May, since they are sitting a little away from us, if you have any final thoughts or views on any of the points that we discussed, and then we will go for closing remarks. Justice Rao, you are maybe on mute.
Yeah. No, I'm not on mute. I think there's nothing further to add. I think it's all
Good. May has something to say.
Yeah, May, you have anything? Maybe some pointers or views that you may want to.
May have to say something.
Nothing so important that I would stand between you and high tea, which sounds delicious.
Okay.
Thank you everyone. On behalf of the attendees and audience today, allow me to thank all the panelists for a very insightful and meaningful session. I request our panelists to please accept a token of our gratitude to grace us with your presence. May I request Suril to please come on stage? Thank you, Suril.
As we speak. I know.
Thank you, Suril, and thank you, panelists. Dear members of the audience, request all of you also to collect tokens as you head out in the reception. Thank you, everyone, for being here today. I'm your host, Shraddha Narayanan, and I wish you all a very lovely evening and a wonderful week ahead. Thank you. Namaste.
everyone who came today. To be very frank, yesterday at the same time, we were very, very worried that whether we should do it here, whether we should change it to Taj. But I think you guys are brave. Let me tell you one thing, that you didn't change your plans and you ended up here. So Zal,
Maybe we
Mr.
can have a
Jarujina, Mr.
photograph with all
Kama,
the panelists
everyone,
together.
thanks Raul for really making this an event. And thank you the whole warrior gang at both the jetties to make things happen. So I think everyone at NDA, please, I think we really were very, very skeptical about it, but I guess it's a success if I can say so.
Can I
Nishith bhai, anything?
No, I think from today on they are all seafarers, adventurers, and try to explore the world. I think you may try to find India, you might find Columbus in America, or you go there.
But now today you found
India.
Alibag.
But I think you found Alibag, and Alibag was, just for a minute if I may take, was the place where shipwreck happened and Jewish settled first time in India here. And that's why Alibag it was called. And then of course, other settlement happened. So, and Bagh is like garden. So, a lot of orchards and other kind of stuff are here. So it's a very beautiful place. This time, because of rains, we could not take you much into the garden and other places because we only see rains. Not today, fortunately, but next time.
I'll advise you to especially invite Justice Nageswara and here.
I want to definitely.
He wants to come here.
And we'd love to have you again. And that will be proof. I think let's ideate, do something interesting, exciting together, focus on purpose. I think we are here to support you, as I mentioned in the beginning. So come up with ideas and let's do something exciting. I think that's where really we can contribute to the country, to the world at large. I think there's so much to do. And we have so much wisdom and experience in this hall. I think we'll do wonders. I think India and we all can do together,